SJC-12159, Commonwealth versus Darius Gibson.
Okay, Attorney
Good-
Curhan. Thank
Good
you.
morning. May it please the court, Dana Curhan for Darius Gibson. I want to start out by saying that the case against Gibson depended almost entirely on the confessions described by Hillary Holden. And she certainly carried a lot of baggage in this case. She had made quite a deal for herself, and she had also falsely accused Gibson of committing an armed robbery that he couldn't have committed because he was locked up. So I think that should be kept in mind as I address these issues, because most of the issues go to the Holden confession. But I want to turn first to the issue of uncharged misconduct, and in particular, a special agent from ATF was permitted to testify about a surveillance video, and he testified that on the recordings, Gibson admitted to possessing at various times 4 different caliber handguns and 3 different caliber ammunition. I think this was there was no need for any of this. We understand that there was other misconduct that had some by Mr. Gibson that had some relevance to the issues at trial. For example, that he sold drugs and that he participated in armed robberies with a knife, but there's really no reason to introduce evidence as to these guns.
I see your point, Mr. Curran. I'm just trying to figure out, is there any significance to it? You know, it's not, I mean, your client, again, because we've got the evidence on the armed robberies, we got evidence that he's selling drugs. Does the fact that he's once had 4 different guns, I mean, especially when the judge instructs not to consider in a certain way, although I have trouble following her instruction too, but I'm just trying to figure out why is it significant?
Well, I mean, I think the initial instructions were, you know, this is really, don't consider this at all. This is really to show that he was familiar with the place. In other words, to show that he was on Creston Street. So don't consider it for anything else. In the final jury charge, she said, well, don't consider it for propensity, but you can consider it for pattern of conduct and things like that. So, you know, the jury ultimately were permitted to consider these guns. But I mean, I think maybe if it was only 1 gun or something there, if he previously had a gun, you know, maybe you get a pass. But if he's talking about, he's got a virtual arsenal here. You know, 4 different calibers of guns, 3 different calibers of weapons, and 2 of those calibers of weapons, of ammunition. 2 of those actually were different from the guns, which could lead to an inference that he had 2 more guns, a shotgun and a .40 caliber. So, you know, I think
Can you remind me, this is just one conversation that the defendant's being recorded on with a confidential informant. It's not multiple different conversations with the confidential informant, right? It's part of one conversation. He's mentioning, I've got this gun, that gun, this ammo, that ammo.
I think there may have been 2. I think there was a discussion of a .22, and then there was another discussion of some of the other ones.
Okay.
So, you know, when you look at this, if the jury had any doubt as to the Hillary Holden confession, you know, they're looking at this and saying, this is a pretty bad guy. This is a pretty dangerous guy. He's, you know, we know he's committed other crimes, but we also know that he's got a whole bunch of illegal guns that have sort of going in and out. And so I think that's problematic for that reason. I want to turn next to the Elaine Bell issue. There are actually a couple of issues incorporated within that. Elaine Bell wrote a letter to investigators, and she essentially said, well, she was at the House of Correction. She said she had overheard Hillary Holden admit that she had blamed someone for a murder in exchange for certain consideration. And when interviewed, she reported that She was getting time shaved off her sentence for some armed robberies by framing a kid for murder that Holden's boyfriend actually committed. So, she's obviously a crucial witness, and the defense identified her as a potential witness and intended to call her a trial.
Isn't there she is just put through the ringer for good reason, by the way, but she's discredited in so many different ways besides this, isn't she?
She certainly is. But the one thing that's missing is she says, I did all of these things, but Gibson confessed to me. He made all these statements to me, and I'm telling the truth about this. Now, what the Elaine Bell testimony would have established is that she did not tell the truth about, that's exactly what the defense was that Hillary Holden described confessions to, falsely described confessions by Gibson. They may have been made by Austin, but she attributed this to these particular confessions. She attributed them to Gibson. And the statement that, she's trying to frame Gibson for a murder that her boyfriend committed, that's something the jury never heard. And I think they have a constitutional right to hear that. That's the primary defense in this case. And what happened was she was in the House of Correction, and she was released very shortly before trial. And I think it was the assumption of the defense that they would just bring her in from the House of Correction and then find out that she's gone and she's moved out of state and they can't find her. So defense counsel 6 days before trial says, look, I need a continuance. This is my key witness. I need a continuance to see if we can find her. And the judge said, no, she's just an impeachment witness. I'm not taking this trial off track. You're going to trial. And they did. And they went to trial, and the jury never heard from her. Now, after trial, I located Ms. Bell, and I got an affidavit from her, and I submitted it in support of a motion for new trial. And the judge denied it without a hearing. And, we contend that, she may have had some baggage. There may have been issues she could have been impeached on. I'm sure she would have been. But I think that there's a real possibility that this may have made a difference in the outcome of the case. And at the very least, the threshold for warranting a hearing on a motion for new trial is much lower than for granting the motion for new trial. At the very least, we should have had a hearing. Put her on the witness stand and see what she had to say.
What legal theory, though? You're saying it was newly discovered evidence? What was the theory?
It's newly available evidence.
Newly
It's
available.
not newly discovered evidence because the defense knew about her all along, but newly available evidence is judged by the same standard. So if, they knew about her, but they couldn't find her. She was, I think they heard that she was in one of the Carolinas or someplace, but couldn't find her. And, she's a registered sex offender. I was able to locate her in Tennessee, and she was willing, she gave me an affidavit, and she was willing to come up and testify.
Counsel, if trial counsel had been able to establish that Ms. Bell was unavailable at trial for purposes of Article 8, would that have changed the ability to get that statement in if she had absconded after getting out of jail?
I don't know the answer to that. I think it may have been, that where there was no right to confront her, to confront that statement. I'm not sure if it would have come in.
Okay. I'm asking because you mentioned this notion that perhaps defense counsel thought the Commonwealth would bring her in, right? So I'm just wondering, what did the defense do to try to secure that Ms. Bell, who has this really important stuff for the defense, that you'd really want the defense to be able to present to the jury? What did the defense counsel do Did he serve a subpoena, a trial subpoena to have it served while she was incarcerated for purposes of appearing at trial?
I don't think he assumed that trial counsel would, or that the prosecution would bring her in. I think she was clearly a defense witness.
So what did he do to secure her to come to trial? That's what I'm getting at.
Well, I think she was gone by the time, I think what normally he would do, and as a trial judge, a former trial judge, I'm sure you can correct me if I'm wrong, he would ask the Commonwealth to issue a subpoena.
Right. Did he do that?
He didn't do that because I think by the time because by that time he found out that she was no longer in the House of Correction.
Okay.
So, and we do make an ineffective assistance to counsel argument as an alternative, but I think he really, in a lot of ways, he did what he could. He found out she was gone and said, can I have a continuance so I can find her? I have a private investigator and we need some time.
Mm-hmm. Thank you.
So that really, I think, that's really the critical issue here that the jury never got to hear.
It
Yeah.
was more than just, I have a private investigator, right? The investigator had been unable to find Miss Bell.
That's right.
Okay.
That's right. And he's somebody I've known for a long time, and he's very good at what he does.
Mhm.
The next issue I want to talk about, and this is not a preserved issue. We contend that the trial judge should have required the Commonwealth to establish the trustworthiness of Gibson's confessions to Holden before admitting them. This is the current rule, and we're raising this under 278-33. The current rule looks at the corpus delicti, which is all that looks at is, did a crime take place? Because we don't want somebody coming in and confessing to a non-existent crime. I shot this person, or I committed 12 murders, or I'm a serial killer, and no crime has actually taken place. I guess the question I have is, how often does that happen?
Well, counsel, I don't know how much that happens, but why do we need to change the rule?
Because
How does it affect your case?
because it affects the rule because there's nothing in that rule that in any way addresses the trustworthiness of the confession. And-
Right. But isn't that for a trial? Isn't that real? As long as you establish that there is in fact a crime, it's not a delusional person. The rest is for trial.
Well, I think before you let that confession in, I think you have to address, whether this is even a remotely trustworthy confession.
But
And I'd say,
wouldn't that happen in a motion to suppress?
I don't think it would happen in a motion to suppress. I don't see the grounds. I think that would address different grounds if there were. I don't see a basis for a motion to suppress. Let me put it that way. And
Isn't there a lot of corroboration here? I mean, even if we adopted your rule, isn't it met here? I mean, the fact that the confession says, hey, they say I shot 7 bullets, but I shot 6, and we actually know he's right on the 6. Isn't that's corroboration too, right? So we don't just have a dead body. We've got a number of bullets here that corroborate consistent with the confession.
what is it that tells us that she is describing a confession by Darius Gibson as opposed to a confession by James Austin and has simply changed the name? I mean, and that's really that's the sort of the third thing that a corroboration rule that they have in some jurisdictions would address. And this is, by the way, this is not something that we would now subject every confession to a voir dire. If it's a confession of the police, I would not advocate for that. If it's a confession to a reliable citizen, somebody said, this is what I saw, or this is what he told me, or this is what my brother-in-law told me, or whatever, I think there's a sufficient trustworthiness where you wouldn't look at it. It's a very rare situation where you have somebody who has, number one, made a deal, and number two, shown to be extremely unreliable and untrustworthy.
So why is it not enough that all that came out in evidence through cross-examination of Ms. Holden?
Well, I mean, I'm not sure how you would, I'm not sure
Why
how
does
you,
it have to be a gating issue as opposed to something that's tested in the crucible of cross-examination and trial?
well, I think maybe it does end up getting tested through cross-examination if the court lets it in. But I think maybe there should be a threshold for the court letting it in. So,
But yeah, so previously that argument has been made and rejected by this court. I'm wondering why you think we should revisit that.
well, because I think, when you look at a case like Burgos, Burgos, the first part of it, maybe you'd want to establish the trustworthiness because he talked about a confession his cellmate made. And, that may raise some questions, but what they did is they had him wear a wire and then they recorded the defendant's statements. So you wouldn't need to do it in a case like that. In a case like this, Hillary Holden is the entire case. And there is a very real possibility in this case that she simply made up this confession, or, maybe not made up the confession, took statements that somebody else made, like maybe James Austin, and said, yeah, it was Darius Gibson who said all these things. How do we know?
Does James Austin meet the same description as your client? Braided hair, the clothing, because there's a very consistent description of the assailant here, right? Is Austin does he have, for example, braided hair at this time?
I don't think so. Austin was, however, he was the one who was robbed. He was the one who was right in front of the place where the shooting took place. And, I think
But we have three, don't we have three witnesses describing, or at least two are describing the person who, shoots the victim, black clothing, braided, long braids, I can't remember. And I take it your client at the time met that description. And you say,
I think he did, there's some difficulties with the descriptions, with everybody's descriptions. Mr. Bonner, the person on the moped, he said he was the closest one there. He said, I didn't get a look at him. Now, he initially, when he called 911, he said the assailant is this Hispanic male wearing a white t-shirt. And he said that to the detectives who interviewed him.
but I take it.
And then he changed it to the
says-
victim.
And is that right, that the victim was wearing a white t-shirt and he's Hispanic?
It's the white t-shirt is true, Hispanic, it's probably consistent. But the other curious thing he says is that the assailant veered off left and ran down an alley. Janice Peters, the person who saw him walk by, said he was casually walking by straight up toward Blue Hill Avenue. She didn't see a gun. And, she gave a description. She said, short pant, black short pants, black, some kind of shirt and braids and nerdy looking glasses. I mean, the thing is, there's a real possibility that people saw Darius Gibson at the scene and on the street and leaving, but that he wasn't necessarily the one who did the shooting. And that's really the point that I think I would like to make. That goes to 278-33E and whether the verdict was against the weight of the evidence, but it also goes toward whether there was corroboration of Holden's testimony or her statement on the confession, and whether her statement was reliable and should have been admitted.
Attorney Carhan, can I ask you two questions before your time runs out? The first is, I haven't dug into the record as deeply as probably you have, but the statement about this is my block now, that there was a witness that testified to having heard that, did that witness also identify the defendant as the person who said that, or by hair clothing or anything?
The defendant didn't say that. The victim said that.
The victim, that's what I mean.
Right. I think he was, I don't recall, but I think there's at least one person
Okay.
who heard that.
The other question I have is I'm intrigued by this issue with Bell. Did the defense ask for a missing witness instruction and get that from the trial judge?
I don't believe he did, and I think, I don't think it would have been appropriate because the Commonwealth, I don't think she was a critical witness for the Commonwealth. And I think by the time of trial, it became clear that she was unavailable. So that instruction wouldn't have been appropriate.
Okay, thank you.
Thank you.
Thank you, everyone. Okay, Attorney McLean.
Good morning, Your Honor. May it please the court. Ian McLean on behalf of the Commonwealth. Your Honor, I'd like to start by acknowledging the family of the murder victim, Terrence Kelly. It's my understanding that both of his parents are watching on the live stream right now. And before we turn into substance, Justice Wendland, I'd like to respond to the factual question that you asked about the special agent's testimony and whether referring to one or multiple incidents. If you look at volume 5, page 58, you can see we were talking about 2 conversations, one in May, one in June.
I'm sorry, what page?
Volume 5, page 58. And the audio or the video clip that was played was from one event on May 24th. And you could see that from volume 5, page 50.
Was that like overkill here? I mean, it's clear he knows the street or he lives 2 blocks from it. So we get in this evidence about the 4 guns for that purpose. I mean, just seems
Well,
really problematic.
respectfully, Your Honor, I don't think it's overkill. And I ask you to take a look at the reasonable doubt instruction. It's a pretty high burden. So the Commonwealth is going to put on as much evidence as it possibly has. The video clip specifically showed the defendant at the location where the murder occurred 4 days before the murder and showed him interacting with the person who was robbed that basically formed the
So
motivation.
could you, I mean, there are all kinds of ways of getting that in without having him putting in the description of the guns, isn't there?
Well, sure, Your Honor, but that evidence was admissible for multiple purposes. As the motion judge found when there was a motion in limb trying to exclude it, that here the evidence about his knowledge and access to firearms would be admissible.
Yeah, but the problem is, and this is really where to counsel's point here, this is backdoor character stuff, right? I mean, the point is it's really not relevant to anything. None of these things were actual murder weapons or have you. And there's all kinds of real concern here as to the jury hating this person because they just think he's a really bad, violent guy.
Well, I disagree with that, Your Honor. First off, I'd say simply owning a firearm doesn't make you a bad guy. I own several. It can be completely legal. So I disagree with your characterization of that evidence, period.
Well,
Second-
you can disagree with me, but we can go back as far as the early 20th century with People versus Zakowicz, where Justice Cardozo talks about this, right? Because this has been going on forever, where the Commonwealth doesn't have necessarily a relevance issue as to it's not the murder weapon. It's not the one that we're going to say is tied to the defendant that they used to kill this person. It's just we're bringing it in for what's the relevance of it? Tell me specifically what the relevance is of these other guns.
This defendant was charged with 10A, Your Honor. An element of 10A is establishing that this person knew the thing that they held met the definition of a firearm, as it's commonly understood. Therefore, their knowledge of firearms is absolutely relevant to that charge. So the purpose of this evidence that he was engaging in braggadocio about having access to a series of handguns and a series of different calibers of ammunition is absolutely relevant to establish that he knew the thing that he held on the day that he killed Terrence Kelly was a firearm. That's why it's relevant here.
But you don't think that Justice Kafka's point is well taken, that can come in without getting into the specificity about what all of these weapons are, I mean, the general proposition could just come in.
I'm not sure exactly. So, Your Honor, I think now we're getting to the question of whether a jury is capable of following a limiting instruction. So, I mean, here the evidence was simply,
Let's
yes.
look at the limiting instruction.
Right.
Because I'll be honest, I'm not sure I know what it means. Now, again, you may consider it solely on the limited issue of the defendant's pattern of operation, intent, motive, course of conduct, and knowledge. That's not very, what is that limit?
Well, Your Honor, I think the instruction you're talking about there is in the final charge. I think we have to start with the contemporaneous charge, the instruction that was given immediately after this evidence came in. And you could see that in volume 5, pages 63 to 64.
I know, but then when we get to the jury at the end, you have heard mention of other acts allegedly done by the defendant, including possession of a firearm. I mean, we can't just, so we have to read this one in the context of some instruction she gave earlier. That
Yeah.
will make it clear that they couldn't consider it for what?
So, Your Honor, what happened here from the trial judge was not ideal. I'll concede that. The motion in limine ruling was that this evidence was admissible for this purpose, knowledge and access to firearms. That ruling was legally correct. The evidence then came in at trial, and then
So
the
when you
prosecutor asked.
say- So knowledge and access to firearms comes in what, intent? Is that knowledge at the end when she says knowledge, that's what you're talking about?
I'm not even close to the final charge yet, Your Honor. This
Okay.
is somewhat of a lengthy response to the question.
Okay, go ahead.
The judge's initial ruling on the motion to eliminate question was legally correct. This evidence is admissible to establish the defendant's knowledge of and access to firearms. He was charged with 10A. It's an element. So that was a correct legal ruling. The evidence then came in. The assistant district attorney asked to go to sidebar and asked the judge to give a limiting instruction. The judge then gave a limiting instruction off the cuff. And I think when she gave
And
that
counsel,
limiting-
is that the one that's at volume 5, 63 to 64?
Correct, Your Honor.
Okay.
Correct, Your Honor. And that was contemporaneous. Immediately after that evidence came in about the agent hearing on audio, hearing the defendant brag about having access to firearms.
And before you go on, do you concede that that was as clunky as the final instruction?
Clunky is a good descriptor, Your Honor, but I think what we have to do is look at the effect of it. And when we're considering the effect of it, we have to consider how a reasonable jury would have interpreted the instruction, not how a panel of appellate judges seasoned in the law would, I look at it in a hyper-technical fashion, but how would a reasonable jury interpret this instruction that was given? What she did when she gave that contemporaneous instruction was remove the firearm evidence from the jury's consideration entirely. So she had previously legally ruled it would be admissible for this particular purpose. It came in and then she instructed him, can't consider it for that purpose. You can only consider this evidence that this witness provided you to establish the defendant's knowledge of the immediate area where the murder occurred and his familiarity with the other players, the other people involved. So she effectively removed the evidence from the jury's consideration entirely. So the defendant couldn't have
How?
suffered any prejudice.
How?
That instruction that says,
Yeah, but the instruction says you can only use it for knowledge and familiarity with the surrounding area. But they've still heard that he has all of these guns.
Well,
So
yes, Your
what
Honor,
are they
but
to
what
do with that?
your question then is you're saying that the presumption that a jury is capable of following a judge's instruction doesn't hold here. And I don't understand why that would be the case.
I suppose that you can, for as much as you can cite me cases that say that juries are supposed to follow it and they do, I can cite just as many that says it's illusory and that people really can't be able to do that in their own minds.
Well, respectfully, Your Honor, I think a lot of those cases that you're talking about now deal with offenses like child pornography and not simply owning a firearm or having access to a firearm. And I think those are categorically different than here. I don't think there's any reason why a jury couldn't follow an instruction from a judge that told them to disregard having heard of somebody owning a firearm and only consider this evidence to establish their familiarity with an area and with a person.
But what about in closing argument, then the prosecutor says, but you can consider that the defendant had knowledge of firearms, familiarity with firearms, access to firearms, both before and after the murder. So it seems like the Commonwealth directly invites the jury to ignore the earlier clunky instruction.
Yes, Your Honor, he did say that. I would point out that you look at the closing argument in its entirety, and that was 3 lines of a 19 pages of transcript closing argument, and nowhere near the focus of the closing argument. It was a single passing reference.
But I guess the reason I mention it is because, so now the prosecutors open the door to, to a more reasonable interpretation of what the evidence came in on. And then at the final charge, as Justice Kafker pointed out, there's this not so clear indication as to what the firearm evidence is coming in for.
Sure, Your Honor. So now we're back into, I guess we're assuming that the jury has not followed the initial contemporaneous instruction, and we're back in a position where this evidence is before the jury. And I would say that's not error. That evidence, knowledge of and access to firearms, is relevant in this case. So that could properly be before the jury.
What about pattern of operation? What does she mean by, the trial judge mean by that? So we've got, you can consider guns for pattern of operation. What does that mean? Meaning that he has a pattern of hanging on, running around with firearms? I just don't know what it means.
It's a clunky, to use the term that was previously used, description of the standard 403 instruction, what you can use prior bad act evidence for, the other things, motive, intent, that list of things right there. So this term that she used here, pattern of operation, that would be absence of mistake. So again, it's relevant because he's charged with 10A, so that he knows what he has in his hand as a firearm is relevant. So that it's not a mistake is relevant, that he previously had access to guns and bragged about knowing about handguns because he knows about the calibers of different handguns. So he knows about firearms.
Is this, do you have an argument that this is all harmless? Because, you know, I mean, we don't like evidence of guns because it suggests that the person's violent or engages in criminal activity, but you've got other evidence that he's violent and engaging in criminal activity. Is this in the end of the day harmless? Because it's clearly clunky at best, and confusing. If I were a juror, I'm not sure I would know what I could do. But does it matter here? Because what we're worried about is what Justice Georges talks about, which is in this kind of casting mud at the defendant. But I'm not sure this adds much here.
Well, it's ultimately relatively insignificant evidence here in light of the fact that he had the gun in his hand and shot the victim 5 times and missed him once. So it's ultimately not the crucial point here in this case. It is, however, admissible, and the judge did limit how the jury could consider it here. So there really wasn't there's no evidence to suggest that the jury was incapable of following that instruction, that they used it for an improper purpose.
Well, I suppose if we were to look at it that way in isolation, but it leads to the other issue that I'd like you to talk about, which really bugs me, is this issue with Elaine Bell, right? So all of this stuff, if we were just to put our blinders on and say, we're just going to look at the guns in and of themselves and relevant to 10H and all of this, that's great. But if Bell comes in to testify that somehow Holden's testimony was really manufactured to take the focal point off of her boyfriend, doesn't it become that much more important then? Because Bell was somebody that would really be important to the defense, and it would really perhaps animate the issue about the additional guns a little bit more to the jury, wouldn't it?
Respectfully, not at all, Your Honor. This witness, that potential avenue of impeachment was completely inconsequential. The witness here, Hillary Holden,
Completely?
was inconsequential in light of all of the rigorous cross-examination and the thorough impeachment and a credibility attack on Hillary Holden as a witness. It came out and was before the jury that witness had before previously lied to police to place the defendant into an armed robbery with her when she was trying to protect Austin, her boyfriend, her significant other. It was very clear to them that she would have exactly the same motive to be doing the same thing now, because she also testified to the fact that she believed she was still in a relationship with Austin, couldn't wait to get out of prison to be with him again. And they knew that she was testifying pursuant to a cooperation agreement. So all of that information was squarely before the jury beforehand. And what Elaine Bell actually would have testified to is that Holden said she lied on somebody in order to be transferred from federal custody to Framingham so she could be with her girlfriend. That's what's in her affidavit, record appendix at 93.
Sure.
So that's merely another relatively inconsequential piece of impeachment.
I think you say that it's inconsequential, but if I'm sitting in the shoes of a defense lawyer, and on impeachment, I'm bringing this out of the Commonwealth's witness, you got to think that the folks that are sitting in the box thinking if that's what he's supposed to do. He's supposed to try to say that we shouldn't believe her. It's a different story to say you shouldn't believe her because I just cross-examined her completely. And oh, by the way, here's another witness who comes in to say that this is what she told me. Doesn't it become a little bit more, certainly more probative when you get corroboration like that with Ms. Bell coming in to say, yeah, it's not just the cross-examination. This is what she said to me.
Respectfully, Your Honor, I don't think it would have mattered at all to this jury here. The witness was thoroughly impeached and they were able to assess her credibility. And they also were aware of the defendant's threats to her to try to keep her quiet.
Mhm.
So when you weigh those things together, I don't think this potential additional impeachment evidence from Elaine Bell would have factored into the jury's decision. But it's also slightly unclear to me which of the three allegations of error we're talking about here. I mean, there are three sort of claims. The first was denial of a motion for a new trial. And then the second was denial of the continuance by the trial judge. And then the third is an ineffective assistance. So I'm not sure exactly which one of those three I'm responding
Well,
to.
it may be relevant to our analysis of all three of them, but I'm just,
So beginning with the denial of the motion for a new trial, the basis was that it was newly discovered evidence. However, that claim is completely eviscerated by his acknowledgement that he knew of Elaine Bell beforehand and what her testimony would have been, that he spoke with her in advance of trial.
Can
So
I
it
ask you to address directly counsel's position that it's newly available evidence and how that might be different than newly discovered?
It's no different, Your Honor. The evidence was available. It was known or knowable at the time of trial. They not only was it knowable, they knew it. They knew about this witness. They
But-
knew where she was.
Well, they didn't know that.
They knew where she was in the months before trial. She was incarcerated until, I can't remember the exact date. She was incarcerated until several months before trial. So they knew where she was and they spoke with her. And then after she was no longer incarcerated, she contacted them in their office and they obtained a phone number from her, interviewed her, and knew that she was staying at the Pine Street Inn. Then they lost touch with her. That happens in criminal trials. You lose contact with witnesses all the time. It happens. It's a part of criminal trials. That doesn't mean it's a basis for a new trial. Then turning to the denial of the continuance from the trial judge, I'd point you to the transcript that we recently obtained that was originally not transcribed, the January 14 transcript. I'd point you to what the defense attorney said in that transcript, specifically at pages 5 and 7. At 5, he acknowledged he was aware of the witness. He'd spoken with her in 2014. She left him a phone number, that he knew she was at the Pine Street Inn, and that he doesn't know where she is now. At 7, he acknowledged to the trial judge that he didn't know if he was going to be able to find her should a continuance be granted. So the trial judge, in evaluating the need for a continuance, factored that into her decision. And you can see that in that same transcript at 19. There was no indication that additional time would result in discovery of the witness. Therefore, you've lost the basis for the continuance here. So the trial judge did not abuse her discretion in denying the continuance here. Then turning to, we're going to evaluate as a claim of ineffective assistance of counsel for failure to secure Elaine Bell as a witness, I point the court to what actions the defense attorney took. And they're the exact actions you would want a defense attorney to take. He reviewed the discovery. He acknowledged he'd reviewed the discovery. He was aware of the witness. He made contact with the witness. He wanted her for trial. He dispatched his investigator to try to locate her 3 weeks before trial. And you can see that from the investigator's affidavit. And you can see that at appendix page 98. And the investigator was unable to locate her. When he was unable to locate her, he tried to get a continuance from the judge. He didn't prevail. That's not ineffective assistance of counsel. That's exactly what you want a defense attorney to do to try to secure a witness for trial. That it didn't work out doesn't render it ineffective assistance of counsel. And ultimately, then the question on ineffective assistance is, would the defendant have been deprived of an otherwise available substantial ground of defense? And he wasn't here because the witness was thoroughly impeached. Granted, we look at it under a different standard because this is first-degree murder. We look at substantial likelihood of risk of miscarriage of justice. And here there wasn't. Again, the same reason. This witness, Hillary Holden, was completely and thoroughly impeached. Elaine Bell wouldn't have added much to the jury's consideration. Turning briefly to my brother's argument about altering the corroboration rule. Here, there's no need for that. The corroboration rule worked exactly as it is supposed to do. The evidence that was presented was that Terrence Kelly was murdered. We did have a body and we had the understanding of how he died, multiple gunshot wounds. So there was a crime that occurred here. There was no imaginary crime. You don't have to be concerned about someone with a mental health issue confessing to something that didn't happen. And then that confession that came in was thoroughly tested through the rigors of cross-examination, as this court recognized in De Oliveira, citing back to the Crawford opinion, the crucible of cross-examination. That is exactly what happened here. It was thoroughly tested, and that's what we want to happen. So there's no reason to readdress or alter the corroboration rule in any way. But even if this court was inclined to do so, the substance of this confession was corroborated. The single most obvious aspect of it is the defendant pointing out in the confession that news reports were getting it wrong, saying that he had shot the victim 7 times when in fact he had shot the victim 6 times. That was corroborated from the ballistic evidence at the scene. 6 shell casings, 6 spent rounds, all fired from the same weapon. That is independent corroboration of the substance of the confession. So that alone would be enough here if you were to alter the corroboration rule somehow. But there was even more in that he acknowledged in his confession what the motivation was, that it was retribution for the robbery of Austin that happened the night before. Another witness testified that Austin had been robbed of $800 and a certain amount of drugs the night before. That's further corroboration of the substance of the confession. So here there's no need to consider readjusting the rule, but if you were to adjust the rule, this factual situation would still satisfy it.
The description of Austin versus the defendant, do we know what Austin looked like at the time of the crime?
Your Honor, no, I don't believe there's anything in the record that establishes anything about his physical appearance. But I would, as you noted during my brother's argument, there were three different witnesses that testified to the clothing, the hairstyle, and the race of the shooter. And here the defendant matched all three of those. And Austin's mother testified as to what he was wearing and his hairstyle that day right before the murder occurred. So he matched the description that was provided by the three other recipient witnesses. And I see that my time is.
Austin's mother describes Austin, or, no, excuse me, whose mother describes who?
Austin's mother described the defendant. The defendant had come to the scene to visit Austin. He purchased his drugs from Austin and then broke them down in smaller quantities and sold them himself. So she was familiar with him from seeing him in their residence in the past. I see that my time has expired. If there are no further questions.
Okay, thank you.
Thank you, Your Honor.